This Honorable Court of Appeals of Tennessee is now in session.
Good morning, counsel. Before we have Mr. Hibner call the case, let me just mention that we don't anticipate any technology-related problems, but if we should have any, everybody just take a deep breath and relax, and we'll work through them. Mr. Hibner, call the case, please.
Hal Eugene Hill versus Liesa Francine Hill.
We'll hear from the appellant, Mr. Jacobs.
Good morning, Your Honors. Phil Jacobs from the Appellee County Bar for the appellant, Ms. Hill, the mother. I'll refer to her as the mother in this case. I've already reserved 3 minutes of time for a rebuttal. This is post-divorce litigation. The petitioner, the father, moved to modify the permanent parenting plan on January 30th of 2015. There was an emergency custody that was granted to father over one of the children, the son, April 23rd, 2015. That's a very important order to name him the primary residential parent. The trial of this case, which is also a very important factor, did not occur until December 4th of 2018. Very, very significant issue is the private school. The son, who was born 1999, graduated from Macaulay School in 2018. The daughter graduated from Baylor School in 2019. The divorce was granted between the parties by irreconcilable differences and adopted an MDA and a parenting plan on July 16, 2013. Almost immediately after that, there was post-divorce litigation that was resolved by a mediated agreement that was adopted on March 26, 2014. Very importantly, both times by agreement, they calculated child support, and then outside of child support guidelines, the father agreed to pay for the private school education for both of the children, both in the permanent parenting plan that was adopted by final decree and in the mediated agreement. The mediated agreement lowered the obligation of father from $2,000 a month to $853 a month based on an increase in mother's income after she had become employed. After the mediation agreement became an order of the court, the father's father passed away, and he received a substantial inheritance of at least $200,000 at one point, $110,000 at another point, an IRA that was liquidated and given to him, recurring income of timber, gold and silver, and other monies that I'll come to in a second. The issues before the court initially is, should father's inheritance have been included as his income? The court excluded it and only calculated child support based on the party's income from their employers. Father, a doctor; mother, a pharmacist. The second issue is, can the court modify father's assumed responsibility for private school if, very importantly, he never pled to be relieved of this obligation? The father's petition filed in 2015 and his amended petition never alleged material change of circumstances to modify his obligation to pay the private school education. 3, this is based on the guideline, which I'll cite in a second. If father never received a court order to modify his child support obligation, can he receive relief if he is in arrears at the time he's making the request? The guidelines specifically say if you are intentionally in arrears, then you cannot then request affirmative relief. And when the father received from the trial court a modification of the permanent parenting plan to the extent that the son began to live primarily with him, and he was a primary parent on a temporary basis, and that order went down July 23rd, 2015, it did not modify his obligation to pay child support. And after the hearing of April 23rd, 2015, he stopped paying child support. So he didn't pay any child support voluntarily between the date of that, quote, temporary hearing all the way through December 4, 2018. And the only time he did pay obligation was when the Maximus services, child support services in a case opened by the mother, intervened in the case and garnished his wages for failing to pay per the previous judgment. The other issues kind of flow from that. It's the contempt issue, whether or not the father was in contempt for failing to pay, the award of attorney fees that the court did grant to father when it should have been granted possibly to mother, and the award of attorney fees for the mother at the trial level, Court of Appeals. The case law on inheritance is pretty clear, and I initially started by citing Farmer and Stark, which has to do with lump sum inclusion, because the request before this court and before the trial court was that the father had $863,000 run through his bank account in the 46 months that this case was pending. And that part of that was income from his job as a physician, but significant amount of that, some 500,000 plus, and some unaccounted for monies were all from inheritance, and that the court should then take the lump sum of that money and divide it over the course of the months that the case was pending, because he actually used the money for his living expenses.
Counsel, excuse me for interrupting. Did the trial court ever request that worksheets be prepared, which would include the inheritance amount with reference to child support?
No, Your Honor. When we tried the case on December 4th, the court specifically found at the conclusion of the proof that he was going to take the father's use of inheritance money to pay private education and cancel them essentially against each other. So never include, the worksheets weren't prepared at different times to be presented, but they were never accepted as a theory from which child support would be granted.
The worksheets were presented or offered, but not considered by the court?
They were prepared by me, I know, and offered at different times under proposed orders or possible proposed orders when we went back on motions to alter amend, but they were never accepted as a way that the court was going to consider handling the calculation of child support.
Your client's position is that the inheritance should be considered in terms of a lump sum as opposed to income averaging. Is that correct?
We would consider it income averaging over the course of the months that he used the money. So again, it's tough to differentiate between money that he earned and had to pay taxes on, which then you'd have to gross up, and then money that just he inherited, so he didn't have to pay taxes on it and just flowed to his account. So that calculation has not been done. But the other cases that are inheritance, the courts have said, all right, well, he had $107,000 and we divided it by 10 years prospectively, or we have interest on a lump sum of money that he will earn, so we'll include just the interest. Well, in this case, because we're only dealing with retroactive, because by the time we get to the end of this case, the children have aged out. So we're not setting actually current support. The only current support we had to really deal with was for 5 months, where Audrey, their daughter, was finishing high school and graduating from Baylor. So because it's all retroactive, because he spent all the money during the time that's retroactive, our position is it should be included as he used it.
Thank you.
Quick question. You said the trial court basically just netted all this out and said, because the father's paying the school expenses, that I'm going to net this money out against those school expenses. Was the trial court asked to do that, or did the trial court do it on its own motion?
I don't think either party took that position. Ms. Raymer, on behalf of her client, wanted mother to pay 1/2 of the school expenses, and then wanted child support to be calculated without the inheritance to be included. My client wanted to include the inheritance in the calculation of child support, and then have the father be responsible for the private school education, because either A, he had assumed the responsibility and not alleged material change of circumstances, or there was no proof of a material change of circumstances because the only real change was that he had inherited $700,000+. So not an argument that could favor modification for him. But again, he never pled that, and that was something that came up kind of day of court.
Okay. My other question is this. Don't the child support guidelines provide a method for how to calculate the school expenses and the private school expenses, as well as an inheritance type situation like this, and provide for credits? Or am I misremembering that?
Well, my understanding is this, that there's earned income and unearned income, and both of those are included in the guidelines definition. Now, Ms. Raymer is right to point out that inheritance is not specifically listed, but gifts are listed, interest is listed, dividends are listed, trust income. So all of these things are listed, and all the case law referred to inheritance always includes it as in some way. So I think the court has discretion on how to include it, but not discretion over whether or not it should be included. So that's that question. On the
Go ahead.
second part of your question with reference to private school, under the old guidelines, it was kind of a pro rata or based on that percentages. But in 2005, when the court adopted the guidelines, when the guidelines were adopted, it changed, and you're supposed to calculate child support based on all the factors to calculate child support. And then the court was to look at a deviation upward or downward for private school education. And the court can deviate upward or downward for private school, but I don't believe, and I can stand to be corrected, that there's a specific calculation or percentage at that point.
That's where I'm trying to get. Did the court do what the guidelines suggested be done in this situation?
No, the court abused its discretion because they did not include the inheritance in the calculation and then do a separate analysis of whether or not the father had an obligation to pay the private school education. And to answer your question, if it wasn't specifically pled, he should have been barred from it. If he couldn't show material change circumstances, he should have been barred from it. Under any type of analysis, was in a much better position because of his inheritance, even after he assumed it, not including his inheritance, to continue to pay the private school education. I see my time has run out, but
Mr. Jacobs, I want to ask you a question, so I'm sure I understand. The order that was in effect when this matter came up had the father, paying child support per the guidelines, correct?
Yes, Your Honor.
And the second part was it had him paying, or he had agreed to pay the private school tuition in addition to what the child support guidelines required.
Yes, Your Honor. The child support was not included in the worksheet, either in the final decree of divorce with a permanent parenting plan or in the mediated agreement post-divorce, to have the private school education costs within the worksheet. It was outside the worksheet. So they properly calculated child support with both the parties' incomes, the day counts, and it gave us a number.
All right. Did I understand you? I'm sorry, but did I understand you earlier that you said that your client's position was that the inheritance income should be included in calculating the child support, and that she would pay 1/2 of the private school tuition?
No, Your Honor, that was the position of Ms. Raymer. Ms. Raymer's position on behalf of the father when we went to trial was that inheritance should not be included as income, and that the mother should be responsible for 1/2 of the tuition.
All right. So your position was that the inheritance should be included, child support recalculated, and father continued to be obligated to pay the private school tuition.
Yes.
All right. Thank you. You have your time for rebuttal.
Thank you, Your Honors.
Yeah. Ms. Raymer, we'll hear from the appellee.
Yes, good morning, everyone. It's a pleasure to be here. I am representing Dr. Hal Hill, and I know I'm not supposed to talk about matters outside the record, but I want to begin with the court's order of temporary custody, because I think there are a lot of clues there about what really was going on in this case. If you look at the trial court judge's initial decision when he transferred primary residential parenthood of the older son to my client, he was quite clear about the mother's personality, that she was aggressive, that she was playing the role of a victim that collided with her role as a mother, and that she had accused the father of poisoning her, and that was a quest that she would not abandon at any point. So there's a lot of history here that's not part of this record. And it culminated in the final hearing when Mrs. Hill did not testify. You know, this is a very unusual case in that Mrs. Hill tried to present all of her evidence through Dr. Hill. There's no affirmative testimony from her. There's nothing in the record that indicates that she wasn't capable of paying the private school tuition. There's nothing in the record that she didn't have the ability to do that. She did not testify. Dr. Hill testified at length about his very modest lifestyle, but there's no testimony from her. And that was a decision made by Mrs. Hill. This record indicates that Mrs. Hill is represented by her third set of attorneys. You know, when she was first represented by Chrissy Mincy, and then by Hal North, and finally by Phil Jacobs. In this case, the trial court judge changed, obviously, custody of Scott from Mrs. Hill to Dr. Hill. There was no testimony at that initial hearing with regard to child support. In his petition, he made a prayer for relief that the child support would be changed. It is my position on behalf of Dr. Hill that, first of all, he does not have to plead that there's a substantial material change of circumstances with regard to child support. That's no longer the standard. Under the child support guidelines, it's a significant variance. And he did ask that the child support be adjusted to make it consistent with the party's income, assuming he was successful in his quest to gain custody or to be designated as the primary residential parent for the party's son. So he did make that request. The distinction here is that he didn't specifically pray that his private school tuition obligation be modified. But it's my position, Your Honor, based on the holding in Barnett, which I think is still good law, that once you plead the matter of child support, you're also pleading the matter of private school tuition because it's one and the same. Private school tuition is a function of child support. And if you look at this mediated agreement, it's quite clear that Dr. Hill intended to pay the private school tuition as an additional form of child support, not that he was paying it as a matter of contract or paying it some other way, but as additional child support, he was paying the private school tuition. So Mrs. Hill, even though she didn't testify, complains about Dr. Hill not coming back to court for a period of years. There are lots of reasons why people don't return to court. You know, sometimes the status quo is remarkably peaceful for all people involved. And it was particularly so for this couple. There were lots of reasons why he elected not to return to court. So finally, the case was set for a final hearing to determine the retroactive child support. And by the way, Your Honors, those were the only issues that were before the court. You know, both parties were given an opportunity to identify issues at the beginning of the proceeding, and they both identified the retroactive child support as an issue and the private school tuition. Those were the only issues that remained at that point. So on behalf of Dr. Hill, I argued that the inheritance should not be considered because whether or not to consider inheritance, even under the case law, the two cases, there are only two cases cited by Mrs. Hill. Under those two cases, in both cases, the decision to include inheritance is a matter of discretion on the part of the trial court judge. It's not mandatory. If you look at the child support guidelines and the inclusion of all of the different elements of gross income, I think there are 23 actually subparts in that regulation. Inheritance is not included. And so I would concede that these unreported cases cited by Mr. Jacobs stand for the proposition that the trial court judge has the discretion, or retains the discretion, obviously, to include inheritance if necessary. The reason I believe that the inclusion of inheritance was not important in this case, or should not have been included, was because Dr. Hill lived such a modest lifestyle. The proof was really uncontroverted that he lived in a rental house. He gave the marital residence to his wife and children at the time of the divorce, or it was part of the property division at that time. He drove an old car.
I mean, Warren Buffett supposedly leads a very modest lifestyle too.
He does.
How the parent chooses, I mean, the lifestyle the parent chooses doesn't necessarily impact the income that ought to be allocated to him, does it?
No, Your Honor, I agree with that. But if you look at his income stream, it was very modest. He's an infectious disease doctor. He didn't make a lot of money. His income was about the same as Mrs. Hill. So I would agree that Warren Buffett lives modestly. I understand he eats at McDonald's every morning, and his wife puts the money in the cup. So I know he lives very modestly. But I think in exercising the trial court judge's discretion, it is an important consideration. You know, if Dr. Hill had earned $300,000 a year or $400,000 a year, I think we wouldn't be having this discussion. But he lived very modestly and had a very modest income. And for that reason, it was my position on behalf of Dr. Hill that his inheritance should not be included. Secondly, with regard to the change in custody or the change in the designation of Dr. Hill as the primary residential parent for Scott, once that designation was made, I think it flows from that there had to be a change in the allocation of private school tuition. My argument was simply that since their income was the same, that the private school tuition should be allocated equally between the two of them. She elected not to testify. As I said, there was no testimony from Mrs. Hill. So there's nothing in the record that indicates that she was not capable of paying half of the private school tuition after the change in custody was made. There is not one bit, there's not an iota of evidence to that effect. And if his income allowed him to pay the private school tuition, then I think it flows from that she had the same ability to pay private school tuition. There has been much made of the fact that Dr. Hill did not voluntarily pay child support after the change in custody was made. Again, there's a backstory there that I can't go into, but the point is that when we had the hearing on the retroactive support, it was clear that had the child support matter been addressed in 2015, when the child custody issue was addressed, Mrs. Hill would have been paying Dr. Hill child support. And so it's a bit, to me, a little unusual, a little disingenuous that she makes the argument that the delay, which would have been to her was to her benefit, that the delay was something that shouldn't have happened in this case. Dr. Hill testified at length. He was cross-examined vigorously by Mr. Jacobs. very effectively. He was cross-examined by the trial court judge, yet we don't have any of that testimony from Mrs. Hill. She wasn't cross-examined by the judge or by me. She didn't present any affirmative evidence on her behalf. The evidence of her income came from Dr. Hill. He's the one that introduced her tax returns through information that we gained by issuing subpoenas to CVS and Lookout Mountain Pharmacy. So there's a lot of history here. This case has gone on for a long time. And I think that the trial court judge, while he did the very best that he possibly could have, I think he should have allocated a portion of the private school tuition to Mrs. Hill. There's nothing in the record to indicate that she couldn't pay part of the private school tuition. And again, I think the holding in Barnett is that it's within the discretion of the trial court judge to determine how to allocate the private school tuition. I don't think there's any hard and fast rule. It's left to the discretion of the trial court judge. I mean, ordinarily, the party paying the child support would pay all of the private school. And that was the holding, as I recall, in Barnett, is that Dr. Barnett was charged with all of the private school tuition. I'm not asking for that here. I'm asking that the private school tuition be allocated between the parents in a ratio that's consistent with their income. Are there any other questions? I feel like I've been talking and not addressing the court. Any questions? No?
I hear none.
Okay, all right.
All right. Thank you, counsel.
Okay.
We'll hear from the appellant rebuttal.
Thank you, Your Honors. The father has the burden on the two significant issues in this case. One, should child support be recalculated? And two, should he be relieved of his responsibility to pay the private school education? Ms. Raymer, as a moving party on behalf of her client, could have called Ms. Hill as a witness. She chose not to do so. When she chose not to do so, that left the proof already in evidence, with mother's income being stipulated, the day counts retroactively and prospectively stipulated, and the husband's ability to pay for contempt purposes stipulated. There was nothing that the mother could have added to the proof at the trial court level to enhance her position, and she didn't need to avoid anything because it wasn't her burden at that point. The issue of contempt was not addressed in my initial argument, and similar to the trial court level, once Judge Puckett determined that he was not going to include the inheritance and he was not going to grant any relief on the private school education, it left us wondering what the child support obligation would be retroactively, and therefore how can someone be in contempt if they in fact didn't have an obligation? So when the trial court abused its discretion and did not appropriately calculate child support, then that left us out of luck in trying to allege that Dr. Hill was in contempt. But what we did know is he absolutely had the ability to pay, because though it's alleged that he had a modest lifestyle, he spent in a 4-year period of time an account from $863,000 of deposits down to $4,000 and had $115,000 in the savings account. So the record is complete in that he spent a significant amount of money in 46 months and had money to pay on contempt. There's a 2-step analysis that the court has to do, and the court failed to do that. It's not in the court's discretion to include earned or unearned income, which inheritance certainly is unearned income, like a gift is. It's in the court's discretion on how to do that. But when Judge Puckett failed to include it, he abused his discretion, and therefore this case should be remanded to include his inheritance and properly calculate child support. It also should be remanded with a finding that the father did not appropriately plead, or there was no material change of circumstances, because it's a two-step analysis or two-part analysis, and they're separate and distinct. And the trial court did not do either one, and the husband was in contempt. All these allegations about why the husband didn't want to go to court, father didn't want to go to court, we tried to avoid those, but we believe he wanted to avoid court. My time is up.
Thanks, of course, thanks to counsel for both sides. We appreciate your briefs and your oral arguments on this.
Thank you, Your Honor.
If you'd call the next case, please.
The Honorable Court is now in recess until 11:30 a.m.
Thank you. That's what I meant. Thank you, counsel.
Thank you.